Zivotofsky v. Kerry, a 2015 case, provides an example of how that question continues to surface. A State Department policy manual had required the passports of U.S. citizens born in Jerusalem to state their place of birth as Jerusalem. The policy began under President Truman and continued through each subsequent president up to and including President George W. Bush. Recall that the modern nation of Israel became a state in 1948 after World War II under President Truman, but that the question whether Jerusalem should be recognized as Israel's capital has been and remains a matter of tense international debate. In 2002, Congress included a provision in an annual Foreign Affairs Appropriations Bill that directed the Secretary of the Department of State to issue passports to U.S. citizens born in Jerusalem, listing their place of birth as Israel upon the person's or his or her guardian's request. This statute was passed by a Congress comprised of a Republican majority House and a Democrat majority Senate and was signed into law by President George W. Bush. Menachem Benjamin Zivotofsky was born to U.S. citizens in Jerusalem in 2002. When his parents' request to have Israel listed on his passport as his birthplace was denied, they sued the Department of State. The case initially began against the George W. Bush administration and continued against the Obama administration. But why did the George W. Bush administration contest the case if President Bush signed the 2002 statute into law? This raises an issue not discussed in the excerpt in our casebook, which we'll come back to when we discuss the presentment clause and the president's veto power, the role of presidential signing statements. Under the Constitution, the president does not possess a line-item veto. The president must either sign an entire piece of legislation into law or veto the entire bill and return it to Congress. This raises problems when constitutionally questionable or politically disputed provisions are included in a long, complex bill, particularly if the bill is an annual appropriations measure necessary to keep essential government functions running. In the modern era, presidents have begun issuing lengthy signing statements, which include the president's interpretive gloss or objections to the bill being signed. It is unclear what legal or interpretive weight, if any, should be given to these signing statements. When President Bush signed the 2002 Foreign Affairs Appropriations Bill, he issued a signing statement with numerous qualifications and objections. One of the objections was as follows. Section 214 concerning Jerusalem impermissibly interferes with the president's constitutional authority to conduct the nation's foreign affairs and to supervise the unitary executive branch. Moreover, the purported direction in Section 214 would, if construed as mandatory rather than advisory, impermissibly interfere with the president's constitutional authority to formulate the position of the United States, speak for the nation in international affairs, and determine the terms on which recognition is given to foreign states. U.S. policy regarding Jerusalem has not changed. This created the odd result of the executive branch arguing before trial courts and eventually before the Supreme Court that a law signed by that very executive impermissibly impinged on executive power. This additional procedural and factual history should raise a red flag based on our discussions of standing in the political question doctrine earlier this semester. Has Zivotofsky really suffered an injury in fact, and even if he has, shouldn't the court consider this whole mess a non-justiciable political question? Indeed, the trial court initially dismissed the case on these grounds, but the Court of Appeals reversed, and the Supreme Court agreed with Zivotofsky that the claim was not barred by the political question doctrine. See the notes in the casebook under the political question doctrine for a discussion of this aspect of the case. The various opinions from the court are notable both for their differing views of executive power and their divergence from expected ideological lines. Justice Kennedy joined the liberal Justices Ginsburg, Breyer, Sotomayor, and Kagan and wrote the majority opinion. Justice Kennedy found warrant for the President's authority over this decision in the Reception Clause in Article 2, Section 3, which states that the President shall receive ambassadors and other public ministers, and in the other foreign affairs powers in Article 2, Section 2, including the power to make treaties and appoint ambassadors. Because of these specific foreign affairs powers, Justice Kennedy thought it was unnecessary to discuss the vesting clause. In his concurrence, Justice Thomas argued that the vesting clause in Article 2, Section 1 does indeed confer a broad general executive power on the President. Notice that Justice Thomas refers to founding-era evidence to support his view, including the writings of Locke and Blackstone, as well as other 18th century legal treatises. The other conservatives dissented. Justice Roberts wrote a dissent joined by Justice Alito, claiming that never before has this court accepted a president's direct defiance of an act of Congress in the field of foreign affairs. Justice Alito further argued that the foreign affairs powers mentioned by Justice Kennedy were inapposite because an optional passport designation has nothing to do with recognizing and receiving ambassadors and public ministers. In a separate dissent joined by Justices Roberts and Alito, Justice Scalia pointed instead to the naturalization power in Article 1, Section 8, Clause 4, which gives Congress the power to establish a uniform rule of naturalization. With his trademark rhetorical flair, Justice Scalia argued that it is a leap worthy of the Mad Hatter to go from exclusive authority over making legal commitments about sovereignty to exclusive authority over making statements or issuing documents about national borders. And note Justice Scalia's contrary originalist reading against Justice Thomas. Justice Thomas's view, Justice Scalia said, creates a presidency more reminiscent of George III than George Washington. The holding in Zivotofsky is relatively narrow. Its most evident and ironic practical impact might be President Trump's recognition of Jerusalem as the capital of Israel in December 2017, and the announcement of plans to move the U.S. Embassy in Israel to Jerusalem. One bone of contention between some conservatives and the Obama administration was the claim that the Obama administration was not supportive enough of Israel. This may explain the seemingly strange ideological alignment in Zivotofsky, with liberal justices finding broad executive power and most of the conservatives arguing that executive power should defer to Congress, even though the United States' reluctance to recognize Jerusalem as Israel's capital began before the Obama administration. In the end, a very conservative administration, wishing to make a political statement about Israel, did what the liberal majority of the court in Zivotofsky said Congress could not do. Beyond the narrow holding and ultimate political result, however, keep the different views of executive power in relation to foreign affairs discussed in Zivotofsky in mind as we consider the war on terror cases in Unit 8.